Hey, Senator James Lankford. I'm actually in Durant today for a bunch of meetings. Great to be out and about and get a chance to visit with folks, but I've had people asking me about the Fifth Circuit decision that came out midnight last night dealing with the chemical abortion medications that are out and what just happened. There's lots of different questions about what just happened. What did the Fifth District just do? Well, a federal judge looked at the FDA decisions, not just the ones that were made in 2000 when this abortion pills first came out, but then the ones that have been made since the Dobbs decision. So here's what happened. In 2000, the FDA made decisions about these chemical abortion pills and said, okay, there are these chemical abortion pills. They went through, they authorized them, but they said there's got to be a lot of restrictions. You've got to actually go to a doctor because they've got to be able to check you out for because there's some very big risks. This particular medication is what's called a black box FDA pharmaceutical that's out there. That means it has a risk of death. It has a risk of severe bleeding. It has a risk of hospitalization. There's some pretty high risks that are with this. This is not like Advil. And I hear some people say, well, it's just like Advil. You should get over the counter. It is certainly not like Advil. This 2-drug series of medications actually causes a pregnancy to have a miscarriage. And so the mom delivers the child at home or wherever she is at that moment. But it is a full-on delivery that she's occurring. In 2000, because of all the risks that are there, and they're quite severe risks, ectopic pregnancies, they've got to be checked, because if you have an ectopic pregnancy and then you take this medication, it could take the life of the mom. You may have severe bleeding with it. You may not deliver all the child, and so you end up with sepsis in your system. There have been literally hundreds of thousands of people end up at the emergency room after taking these drugs and trying to do a do-it-yourself abortion at home. So these are not a no-risk set of drugs. So those decisions were made by the FDA in 2000. And then after the Dobbs decision, the FDA, for political reasons, seems pretty apparent, said we want more people to have access to abortion. So they made several changes. They said you no longer have to go to a doctor. You can just go to anything they define loosely as a healthcare professional. Didn't have to be a physician. You didn't have to see a physician in person. You didn't have to get checked to see, for instance, you have Rh negative blood type, because if you do have that, there's a chance that taking these medications could actually sterilize you in the process and you'd be infertile. You didn't have to check for any kind of heart conditions or kidney or any of that other stuff. The FDA made this decision on it. That's what the court just ruled on in the Fifth Circuit. They came out and said, hey, listen, we're accepting the 2000 decision, but we're not accepting these recent ones from the FDA. And so here's the big issue that's actually going on with it. It now goes back to the 2000. It is still available, but you've got to actually be only 7 weeks into gestation. You can't be up to 10 weeks, which was the new FDA decision. It also comes back and says you've got to actually go to a doctor. You just can't get these mail order and do-it-yourself abortions at home. You've got to actually go to a physician on it. And then the third thing on it that surprised a lot of people is FDA recently told all folks, hey, you don't have to return in if there's a problem. If there's a problem, if you go to the hospital with it, you don't have to turn it in that there's a problem unless the woman actually dies. So what the FDA decided a few months ago was if there's excessive bleeding, if you have an ectopic pregnancy and you end up in an emergency room, if you have sepsis, you no longer have to quote-unquote register those things. Only if the mom dies is the only one that you would actually have to register as a problem. That seems nonsensical to me. What the court did in the Fifth Circuit is said, no, you've got to actually still submit every single problem with this drug. What the Biden administration is trying to do is to say, just ignore all of the risks to moms that are out there. Ignore the hundreds of thousands of people that have had problems. We don't want to know about those anymore, only if she dies. That's the only thing that's become an issue. That's not true for other drugs. That certainly shouldn't be true for this as well. So there's a lot of things the Fifth Circuit did. It's not over in this process, but what they basically said is if these chemical do-it-yourself abortions at home, you can't just get a mail order and get it because there's so great a risk. FDA's got to be able to show, why do you not have to get to a doctor? Why do you not have to list if there's other problems, you end up in the emergency room? And why can't you just get a mail order and not have to see anyone at all? So that's what's happening in the process. And we'll see where this court case continues to be able to go in the days ahead. In the meantime, I'm not only passionate about protecting the lives of children, I'm passionate about protecting the lives of all those moms that are taking this do-it-yourself abortion kit at home and thinking it has no consequence when it clearly could have very, very serious consequences for them as well.